We wanted to try and keep this session light today because legal can be a heavy topic. So we'll keep it light and interactive. So please ask us any questions as we're going along. Just first of all, we both thought we'd introduce ourselves. As Vaishnavi said, I'm a partner at Baker McKenzie. Baker McKenzie is an international law firm. We have offices here in Hong Kong as well as in China and about 70 other places in the world. I lose count. And my focus is in IT and communications. So very much in this space, helping clients with moving in. We're mainly dealing with multinational clients, but particularly where they're coming from another jurisdiction and moving into Hong Kong and wanting to set up their e-commerce business in Hong Kong. And we deal with a lot of IT regulatory issues as well as privacy and data protection issues, which is very much also associated with doing business online. Much less glamorous than Katy's business, of course, so I'll let her tell you about that.
Well, firstly, I'd just like to thank Anna for inviting me along today. I am certainly no legal expert, or I will not claim to be. We're not lucky enough to have one of those in our small organisation, but I'm hopefully here today to share some of the experiences that I've had from a legal perspective as being an online entrepreneur, so hopefully there's some useful things you can take away. So as introduced, I'm the CEO and co-founder of Upper Street, and for those of you that don't know about Upper Street, we're a custom-made shoe company where women all over the world can design their own shoes. And how that's delivered is in two ways. First of all, you can visit the website upperstreet.com, and we have a 3D design studio where you can create your design. Or secondly, we have an iPad app, which we launched last year. So once the customers design the shoes are then handmade in our workshop to a high quality and then shipped out direct to the customer, direct to their door within about 4 weeks. So I think that's probably enough about me. I mean, we're primarily at the moment UK focused. That's where 80% of our sales are. So not that well known in this part of the world, more so in the UK.
Much more glamorous than giving legal advice. Okay. So we'll see how we go. But anyway, what we wanted to do, it's always the technology lawyers that have trouble with the technology. Right. Just wanted to run through, we've only put together a few slides and they're just really to guide the discussion. We wanted to run through 3 key areas here. Setting up your business for an online environment, establishing your website or your online presence, and then running your website. We wanted to look at the legal issues that come up along for each of those steps. And I'll kind of give you a bit of a background as to what the actual legal issues are, and then Katy's going to give you some insight as to how she came across those issues or dealt with those issues as an online entrepreneur. So we're going to do this very much as an interactive session between ourselves. So similarly, please, if you have any questions on any of these topics, don't feel obliged to wait till the end. Let's keep it. It's the end of the day, so let's keep it a dialogue as we're going along. Okay, so starting with setting up your business. There's a couple of key things that you need to decide right from the outset, and you need to take on right from the outset when you are looking at any business, really. This applies to kind of online and offline environment, but they can be particularly pertinent in the online environment. First of all, what kind of entity you want to set up, or what kind of entity you want to use to take your business forward. And what I mean by that is, are you just going to be a sole trader, building a business in your own name, or do you have a partner that you want to, build the business in both of your names, so you take it forward as a partnership? Alternatively, you might have a partner or a number of people that are interested, so it may be better to set up a company and you all become directors and shareholders of the company. And the benefits of doing that are that you'll have a legal entity there that can be the owner of the business. You can get investors later on who might want to invest and take an interest in that company rather than in you personally, which becomes a lot more difficult. There are tax benefits. This is, like I said, not a question that is necessarily specific in the online environment, although when you get around to registering domain names and trademarks, which I'll talk about shortly, then you might want to consider, well, if I've do I want those ultimately to be held by the company that's operating my website? In addition to that, the type of entity is really the location of that entity. And that this really will depend on a couple of things. Firstly, on tax, where is the most tax efficient place to have your business set up? And then secondly, it will also depend on where your target market is. Is your target market going to be in Hong Kong? Is it going to be elsewhere? Where does it make sense to have your company? So, and that's often a challenge when you are operating an online business, because you can be operating it from anywhere and targeting another market somewhere else. So, a couple of basic things to consider.
That was certainly a major consideration for us as a business, because I run the business in partnership with my sister Julia, who's based in London. So being here in Hong Kong, naturally I felt, we should set up the business in Hong Kong. It's a much more tax efficient jurisdiction. Why do we want to be giving all this money to the tax man when we could set up here? And also it's so easy to set up a business here in Hong Kong. But we talked to a number of friends who are lawyers, and we talked to a number of tax consultants, and they took a look at our business and they said, well, two things here. First of all, your business is called Upper Street London. You're a British company run by two British girls. And secondly, look where your product's going to be selling. Yes, you're online and anybody could buy you anywhere in the world, but all your marketing is targeted at the UK at the moment. So to try and convince the tax guys in the UK that you're not a UK company is going to be pretty hard. They're going to want to come after you for that tax. So we took the decision then and there to set up in the UK. We did consider briefly kind of different, more convoluted structures. But the advice we took really is, while we were still so small, we didn't want all our time and energy to be sapped up kind of trying to work our way around kind of, avoiding being a UK company. And for us, while we're still so focused on the UK, it doesn't make sense. However, of course, the structure can be reviewed at a later date. So as we take our business international, we can perhaps revisit that structure. But for now, we're a limited company set up in the UK.
I think that's a really good point, because it's very important to plan ahead in terms of your structure and in your tax planning. But if your business evolves and grows, which of course is the intention, you can expand the structure or move to a different structure at a later stage if something becomes more efficient, or it's better if you're bringing on an investor, or depending on what the circumstances are. So you don't need to be fixed to it, but it definitely pays to have a little bit of foresight into what the structure is. The second sort of point or second thing on this slide that we really wanted to talk about, and it's really important, is registration of domain names and registration of trademarks. And I just thought I'd give you a little bit of an outline on what the difference between these two are, because often the two of them are lumped together and they're both very important, but they both serve a different function and they are different things. So when you're talking about a domain name is actually really just a contractual right to use the URL. So you sign up with the registration body. You find your URL. You can do any. You might not be able to find the exact one that you want, but you might be able to find a slightly different variation. So you might be wanting to have Upper Street, but it was taken, so you could do Upper Street London, for example, and then you've got so many different domains to choose from, different countries. So there are a lot of different variations there, and you can pretty much quite cheaply sit on the net and register away domain names. You can register different variations in different domains. It's not expensive, it's not difficult, and you get the use of those domain names. What you don't get from registering domain names is any real kind of exclusivity over the use of the name. You get a right to use the URL, but that's it. So if you want to get exclusivity over the use of a name or a trademark, then you need to go ahead and register a trademark. Now, a trademark is different from a domain name. As I said, a domain name is a contractual right to use that string of letters as a URL. A trademark is an actual intellectual property right. It's an asset in itself. So it's a thing that you can buy, or you can register. You can buy trademarks. You can sell trademarks, you can license trademarks to other people. It's actually like a piece of property. And to register trademarks, it's a much more difficult process in that, first of all, when you register a trademark, you can only register trademarks on a territorial basis. So you'll register a trademark in Hong Kong, in the UK, in Australia. It has to be done on a country-by-country basis. And there are some treaties between various countries which allow you the benefit of being able to do multiple registrations more in an easier manner, but you still need to undertake, the sort of the country-by-country registration process. So if you are looking at registering trademarks, then you need to again think about, what's your target market. You can only register the trademarks for particular goods. You can't just register a trademark and then, you think that gives me the exclusive right whether I want to sell plumbing services or horse riding or whatever. You actually have to be quite specific to what the trademark registration is for, and you also have to, select the countries that you want to register in. And there is this kind of belief that if you've registered a domain name, that'll give you the right to the trademark. That's actually not true. It can be helpful if you ever get into a dispute when you're going through the trademark registration process as to whether you've used that before, to say, I've registered the domain name, but it doesn't give you a right to register the domain name. So in the trademark process is not a matter of getting on the net and filling out a number of forms like it is for a domain name. As for trademarks, you have to go through the registry in each country. There will be an application process. You apply, you get a date from which you apply, which, if you're ultimately successful, will give you the monopoly rights back to that application date. You apply, and there's actually like an examination period where someone in the trademarks office in that country will look at the trademark and say, okay, is that trademark a bit too similar to this other person's trademark that's already registered? And they might require some variations, or they might require you to come and prove to them, no, actually, this is distinctive. This mark, is what people will associate with my brand. So it's a more difficult process, and it can often take years. In China, it takes a couple of years from the time you put in your application to the time you're approved. I think in India, it takes 4 or 5 years. It can take quite a lot of time. So that's the sort of the legal basis there. Yeah. Yep.
And I got a letter from mainland Chinese companies saying that we have trademarked this, and if you want to continue using this, you need to buy a right to do this. And I got it twice from different companies. Is this something I should worry about? I totally ignored them.
Well, it depends if it's true or not, because there are some mainland companies that are making a business of finding domain names and then registering the trademarks, and then holding it over the domain name owner.
So does that mean that I have to stop using it as my domain name if they happen to really own the trademark?
Technically, yes. If they were going, they could. Well, a trademark gives you like a monopoly right over a name. So if they could come back and say, hey, that's our trademark, stop using the domain name because we're using this trademark, well then yes, you would have to stop doing business in China under that name.
Oh, only in China?
Yes, because it's only a monopoly right. There's a lot of scams going on where they're just trying to get money out of people, so it may not actually be true because people just get scared. The second thing is you can, if you think they've just registered it to basically blackmail you for money, you can also challenge that registration with the trademark office. It's not an easy process, but you can go back and say, hey, look, this was my domain name. I've been doing business in China for many years under this name. They've only registered this mark to elicit money from me, and you can work to get the registration removed from the trademark office.
But don't they have to, when someone bought a domain name, don't they have to prove that the business is actually related to that particular domain name? So I think I remember there's a law out there that you can't just buy any domain name unless your business is actually related to that domain name.
Not necessarily. It's very easy to register domain names. There is, again...
Trademark, sorry.
Oh, sorry, trademark. Trademark, that's how the process should work. But, I mean, there's only limited resources in the trademark registration office. So they'll look at what the other trademarks are that's registered, and then they actually advertise them. And, in this advertising kind of process, then you could say, hey, that's my trademark. I've been using it. Someone's registering it, and yes, you can challenge the registration. They may need to undo it. Many years ago, I did more trademark law than I do now, and we used to, the law firm I worked for at the time in the trademarks group, every month when this journal came out with all the newly registered trademarks, we used to flip through it for our clients to find if anyone had registered anything similar, because you have a certain period of time that you can challenge them. So yes, but it's quite incumbent on the trademark owner to be vigilant about that.
Thank you.
Yeah, I suppose I'll just quickly share through my experience on the whole registration front and the trademark side. So when we came up with the business idea, my sister and I were sitting in a restaurant one evening. We got incredibly overexcited and wrote our business plan on a piece of paper, ran home squealing, we were going to call it the Little Shoemaker, and we brought up every iteration there was of the Little Shoemaker possible. The .com, the .co.uk, the Little Shoemaker, shoemaker.com. And then, it was cheap and easy to do. It didn't cost too much money, thankfully, because a few weeks later when we started to look at how we were going to market the business, we felt, Little Shoemaker doesn't feel quite right where we want to position ourselves. So we decided to go for the name Upper Street. And this time when we looked online to see if anyone owned the .com, because we really wanted to own the .com, that's kind of quite key if you want to really take that brand. An individual owned that. That was really frustrating. At the time they were selling it for, I think, €6,000. We didn't have huge budget. Quite frightening. We managed to negotiate them down to €2,000, and even then that felt like a lot of money at that time. But I would say it's one of the best investments that we've made. Having that .com is really, really important. So I think, if there is the opportunity to come up with a name where you can own that .com, I would really recommend that you do that.
Sorry, just on that, what's your view of websites that have hyphens or any other kind of abbreviations?
It's okay, but at the end of the day, it's always going to kind of work against you when it comes to kind of things like SEO, Google listings. If you can own the .com, it's really going to pay off, depending on what they're charging for the .com. I was listening to a presentation, I think it was by Anya Highmarsh the other day, and she was saying in some respects it almost worth just making up a name just so you can get the .com, because it really is that powerful. But that's just speaking from our experience. I know how it's really helped us with our search rankings. We've also along the way kind of taken URLs that we thought were important to our business. So for example, a year into the business, we started to launch shoe design competitions as a way of getting customers engaged in our product. And we gave them the brand the Golden Shoe Awards. And the more we used this, the more we thought, actually, we better take the URL for the Golden Shoe Awards as well, because otherwise somebody could simply come along and do the same thing and steal that away from us. And we'd already spent quite a bit of money developing the assets and what have you. So, there are also other URLs that you may end up needing to take as a kind of defensive strategy. On the trademark side, whilst we're currently focused on the UK market, we've always had global ambitions, but registering trademarks is expensive. It really is an expensive business. So the likelihood that you're going to have the budget to go out and protect all of those countries in one hit is pretty unlikely. So our approach was really to register in the UK to begin with, and then as we had the cash, we went out and registered the markets that we thought were most important for us to protect in, one of those being China, of course. And it's really important to think about what your global ambitions are going to be. It happened to a friend of mine, in fact. She runs a very successful business in the UK called Save Your Soul, and when she went to look to move into the US, somebody already was operating under that trademark. So then you've got the problem. Do you enter the market under a different brand? You've already built up all the brand equity in the market that you've been operating in. If you change your name, you lose all that. So it's really worth thinking when you sit down and come up with what your trademark plan, your brand name strategy. What do you want to be as an organisation? Do you want to be staying as a local operator, or do you ultimately have international aspirations? So I think, as I say, trademark marketing is expensive. I think it cost us about 5,000 Hong Kong dollars just to get the registration in China, but I'm so glad we did it, because I had an interesting experience, I think about a year ago, and I was hiring for a technical director to come in and work with the workshop that we were setting up there at the time. And I conducted the interview, and he was a great guy, but he seemed to kind of ask me a lot of questions about our commercial strategy in China, and seemed to be more and more interested about that side of the business rather than the kind of shoemaking thing that I was actually going to be hiring him to be running. And I found it all a bit strange, and then sure enough, a couple of weeks later, someone alerted me to the fact that somebody was trying to register the trademark Upper Street in China. So I was just like, I'm so glad we got on that list first. It's worth doing. So as soon as you can afford to protect those markets that you want to go into, I'd recommend go ahead and do that.
I have a question based on the discussion that we're having right now.
So would it mean that if, for example, right now my company is called Alchemy Consulting. Now, if I wanted to do business in China or Europe, I could go and register. So would I need to just buy a domain name with dot something for that country? Or?
Firstly, you could go and buy the domain name, which would provide some kind of barrier, because it would put people off setting up that company because you already own the domain name. But it's not going to fully protect you. And if somebody could actually go and register the trademark, and then they might have an argument with you where they come back and say, well, we own the trademark, what are you doing operating in our market with that URL? Off you go.
Right.
So the domain name alone is not enough. You really need to get trademarked in those countries.
Okay, thank you.
So you mentioned that for trademarks, it's registered in a very secluded segments. For example, you can have ABC in the clothing sector, you can have ABC in the plumber section. So if one trademark that is registered in a clothing section, knew that there is an ABC.com registered by the plumbers, segment, can they argue with them? And because both of them have the trademark, but it's just in different segments.
You wouldn't be able to have the same trademark in the same market. Maybe I've confused the question here. So ABC dot.
Oh, so the company's name is ABC.
Yeah.
So ABC is actually registered as trademark in 2 different segments. So that is actually possible.
Yeah.
For example, one is a clothing company, the other is maybe a plastic company.
Yeah.
And then the plastic company actually registered a domain name first. So it has abc.com that has a website on plastics. And there's another company that has already registered a trademark in the clothing for ABC company. So can the ABC company get into any dispute with them? No, right? Because they're legitimate in using the domain name. Thank you. And also one final question. Yeah, I know it's kind of complicated and interesting. And my question is about the different variations of a trademark. Because for a logo, you can have like an emblem. You can have the words in different colors. And for example, when a person first registered a trademark, it can be in plain black Arial color. And then they change the font and the color. They have to register it again, right? And also, the issue is that what if some people register the same name in a different form and color, which would kind of confuse people into seeing that they actually own that brand as well. So how do we solve that?
That's what the examination process is there to prevent. So, when you make your trademark application, then there are people in the trademarks office who will look and say, are there any other trademark registrations or applications that are confusing or similar to this new application? So if you've just registered a trademark in plain print, Upper Street, for example, then it's going to be very difficult for someone to register that in the same class of goods just because they put a logo in there or just because they changed the font. But if your first registration is a very elaborate logo with the words in it, and then someone then comes and does another completely different, distinctive, elaborate logo with the same words in it, then they may be considered in the examination process to be different enough from each other. So that's why you you always start with just registering your words as a trademark, and then you can go on to logos and stuff later on. Because also you might want to change your logo, but you might keep your company name the same.
Yeah, I've got one more point to add on that. It's quite interesting when we registered the trademark in China, because in the process, the bureaucratic process, they came back to us and actually said that we weren't able to use the words London as part of our logo. It's a part of our logo underneath, and we had to remove that because we weren't able to make any reference to a location. We weren't able to own that. So in China, we have a different logo as a result.
So can I have one final question, very quick one? So in the scenario that I have registered a trademark, very plain one for the name ABC, for example, and then I also, bought a domain called abc.com. So I'm legitimate in using that, no matter what other variation of the trademarks would have already been registered by others. Is that correct?
Yes.
Thank you very much. Thank you.
I have a question just related to the usage of the trademark. So if I were to register a trademark, say in China, I've already registered one in Hong Kong, but my business doesn't expand into China, not for several years, could someone else take that trademark because I'm not using it? I don't have a business in China?
They could challenge it. I mean, if you've registered the trademark, it's been passed, then you've got the trademark until someone challenges it. But if someone sort of came out of the woodwork and said, oh, actually my business, they tried to register, for example, then they could show, oh, I've been using this name for 12 years, but I haven't actually ever used a trademark before, then they might challenge yours on the basis of non-use. I mean,
Okay.
it's not necessarily easy, but it can happen.
Okay, great. Thank you.
I think of the lady down there.
Sorry. Just a question about the .com. If I register the abc.com, can somebody else register .com, .hk, .com, .cn,
Yes.
for example?
Doesn't give you any exclusive rights.
Okay, so it's better that I register all the market, and now there are abc.hk. So what's the difference, and how many domain names do I need to register?
It just becomes defensive in the end. It's not, if you want to, large companies will register literally hundreds and hundreds of domain names to stop people registering any variations. But you've got to take, when you're a startup, you've got to take a view at some point and say, well, maybe I want to get all the HKs, .com.hk, whatever, and the .com. But you can't. There are so many countries with so many domains that you literally can't take them all. So it just depends on how much you want to invest, and you might have a view on that. I think you.
Yeah, I mean, there's still a number of markets that we've not done that are smaller markets, and I think you just have to decide what level of risk you feel comfortable with, really, because you can't do it all unless you've got massive, big marketing pockets.
Thank you.
Registering your name globally is difficult. It is. I registered in Hong Kong. How do you actually register it, let's say in China? I mean, do you have to hire an attorney there? It was difficult to find one here. How do you find one globally, or do you do it on the internet? How did you find someone to
Registering your
handle?
trademark.
Oh, to find someone to do it.
Yeah, in fact,
Let's say in China, how did you do it?
I actually found there's an office here in Hong Kong that will do trademark
They did it.
registration on your behalf for you. So
Do
you
they
just tell
do-
them what countries you want to be in, and they will help facilitate
Globally.
that. Yeah.
They'll do it globally.
Yeah.
Right. Okay. That's difficult.
It's why it's sometimes easier to use an agent. A bit more expensive.
Yeah, you don't necessarily need to use a lawyer. There are, as Katy was saying, trademark agents that are cheaper than lawyers, and they'll just have contacts in various jurisdictions, so they'll just they can take care of that. And the other benefit of using an agent is they'll know the nuances of each country, because the registration process is not the same in each country, and they can help you with making sure that how you describe the services or the goods that are associated with your trademark is adequate and will cover your trademark registration. And they'll also help you if you get any challenges. along the way, or the examination comes back, for example, with, you've got to remove this word, they'll help you with that. And then the other benefit is that once you've got a trademark, you don't have it forever. It has to be renewed. So the agent will also have a bring up kind of system that will remind you, your trademark's expiring after, a couple of years, you need to pay some more money and we'll do the renewal. Because it's not the same period. Some countries it's 5 years, some's 10, some's 2, just to make it even more confusing.
Sorry, what's the difference between trademark, registered, copyright, all those different things?
We'll get to that. Why don't we move on to the next slide? Yeah, seriously. Well, we knew that intellectual property would be key, and why don't I jump straight to that ownership of IP, because this is obviously a really key topic. So the main types of IP that you'll hear the differences of are trademarks, patents, and copyright. Trademarks give you a monopoly. It's a registerable right, so you have to register it to get the benefit of a trademark intellectual property right, and it gives you the right in a particular country to have sole use of a name or a logo for a particular class of goods and services. So basically, if you've got Upper Street for shoes and someone else in the UK starts using Upper Street for shoes, you've got a whole raft of rights under the law that you can use to stop someone else from using that name. So the next one in that category is patents. Patents is also a registrable right, so you only get patent rights if you've gone through a patent registration process. Patents protect ideas. So if you've got a great idea, you think it's original and no one else has thought of it anywhere in the world, basically, then you can register a patent. And it's quite a difficult process, an expensive and a time-consuming process. It's usually more associated with physical inventions rather than business ideas, but you can use a patent to register a business idea if you've got something that is completely novel. Now, again, a patent registration is done on a country-by-country basis, but when they go through the examination process of a patent, the examiners actually will search patent registers around the world to make sure it's really the first time that anyone's thought of that idea. And the reason is you get, I think in most countries for a patent registration, you get about 20 years monopoly, so they really make sure that no one else has thought of that idea before. The third one is copyright, and copyright is simpler in some respects, in many respects, than trademarks or patents, because you don't have to register a copyright to have the rights. Basically, copyright is an intellectual property right in original work. So whether it's a photograph, whether it's a literary work, something you've written, an artistic work, something that, a painting, or a compilation of a number of things, like a website is text and photos and colours, and it looks like, or when it's all brought together, it's a compilation. Just by merely putting effort into something and having originality, you get copyright. But what copyright protects is it's not so much a monopoly right like the other two, but it protects you from someone copying it. That's why it's called copyright. So if someone independently comes up with exactly the same thing with never seeing what you're doing, then they haven't actually copied what you did, then there's no breach of copyright, as it were. But if they've seen your great idea, or you've seen your text, it doesn't protect ideas, it protects the text, and they copy it, like you've written a book, they copy the book, then that's where you have copyright.
So you have to actually copyright it to get that protection, or
No,
by default?
It automatically exists.
And so on a website, how do you protect that? How do you know if someone's seen your website or not and copied it?
Well, it can be, it can be difficult, for a website, you know the date that you first published the website, and if someone copied your website, then, and you knew that website only, appeared like a month later or whatever, then, that you just have to kind of collect that evidence and prove it ultimately in court that, that this website copied my website. It's not as easy as I registered it on this date, like a trademark. It's a much more difficult process.
So you don't need to put that little C next to your brand or your logo or anything to get copyright protection?
It's not a requirement, but the C is like a claim, you know, making the world at large know, hey, this is my copyright, you know, hands off kind of thing. So best to always put it on there. And a lot of people put the C with a year or a month and a year because that's kind of the date that it was created. So, you know, ultimately if there was a dispute, you could say, well, look, this is my copyright. I've created it in, you know, 2010. So, you know, let's, you know, yours only appeared in 2011 kind of thing. So the other part of that, and just going back to ideas, because everyone wants to protect their ideas more than often the text. You know, you can rewrite something, you know, but it's like, I've got this great idea. I don't have time to patent it. I want to take it to market, but I want to go and talk to people about it. So, you know, how do I protect myself and my idea without having to go through this lengthy and expensive patent process? And really the only way that you can protect an idea is to have a confidentiality agreement when you go to talk to someone. So if you're going to pitch a good idea, you're going to talk to a website designer, you're going to talk to anyone, potential future employees, you know, you may want to put a confidentiality agreement around it. And again, that gives you a legal kind of claim saying, when I came to you, I told you this was confidential. After that meeting, all of a sudden my idea's out in the market, and you can, you know, gives you a legal basis for, you know, for taking action.
That same scenario happened to Facebook, so it doesn't really work. You know, when you go to have someone. Anyway, how do you have somebody do the
Trademark and the pattern and the patent and the copyright. Is it same agent that does all that?
Well, the copyright doesn't need to be registered, it just exists. When you create something, copyright exists in it.
How about the patent, and is that the same trademark agent that does that? Same?
One thing-
patent agents? Different agents?
One thing to be kind of careful of when you're a small organisation is you often work with kind of outside suppliers because you don't want necessarily in-house staff doing everything for you. So anything that your own staff creates is automatically the copyright of your company. However, if it's an external agent that's created that, you don't necessarily have the copyright. So what you need to be sure of is when you're entering into an agreement with a third party, that you make it clear that you will own the copyright for those,
Right.
those assets.
As I understand it, when you copyright something, you have to just mail it to you, and you keep that as a proof that it was by the mailing stamp that you've done it at that time. Is that correct?
You don't have to do anything to get copyright protection. That just comes down to proof again. If you ever wanted to take copyright action against someone, you might want to have that.
Right.
A simple email would probably be
It's
okay,
simple.
would it not, through with a third party or would you recommend a firm legal agreement on these things?
On copyright, if you copyright claims versus copyright assignment are two different things. So the minute you put pen to paper, the minute you take a photo, the minute you do any of those things, you've got copyright in
Right.
whatever you create. You don't actually need to take any other step.
Okay.
Whether you take any of those actions like mailing it, putting the C on there, whatever, they go to proof if you need to take action
Yeah.
against someone copying you
Right.
later on. To Katie's point, which is a really, really important one, is about, you know, when you're using third-party providers and they are creating things for you, even though you're paying for them, the basic position is that the person who created something is the owner. So
Right.
they've created it, you've paid for it, you've paid for a license to use it, but unless you put in your contract specifically, and you need to put it in black and white, it actually has to be in writing, that they are going to give you the ownership of the copyright, then you don't actually own it. So you'll have a right to use it, but you don't have a right, you don't own it, and you can't then let someone else use it, for example. You're under their, you know, under their control to some extent. And
As a business, I've got quite an interesting story to share on this one, because obviously the unique thing about Upper Street is the fact that not that you can buy shoes from us, but the fact that you can design them yourselves, and it's the piece of technology that lets you do that is the interesting thing. So what, from the consumer point of view, is an easy 7-step process. Behind the scenes, it's a lot of technical development, hard work and money. So just to kind of put things in perspective, when you go onto the site, you'd select your toe shape, your heel height, then you'd select your front, your back, your straps. Then you've got 150 different materials that you can colour the shoe in. That is 600,000 different images sitting on a database that the Flash application is tapping into. And the complicated piece is the piece of code that brings it all together to give you the beautiful shoe. And you can see that in 3D. So you can imagine that's quite complicated. Yeah. When we enlisted the agency to help us to build this, because we didn't have the tech expertise in-house, we, naive as we were as entrepreneurs at the time, just assumed that we would own the IP. And it came to the end of the web build, and we found out, oh, we don't actually own the IP for this code. Wow, you know, this put us in quite a nerve-wracking position. So at the time, we totally overshot our web budget, as everybody who seems to develop a website always does. And, you know, we didn't really know what to do, but, you know, we had a very decent partnership with our web agency, and I think it was also an oversight on their part. So we entered an agreement with them whereby it was a 2-year exclusivity agreement where no one else could use this technology, and at the end of the 2-year agreement, we would have the right to buy it. Now, of course, what happens at the end of the 2-year period, Upper Street's doing very nicely, thank you very much, in the UK. Cha-ching, the dollar signs go off in the eyes of the agency. So, of course, suddenly the price gets jacked up. It's like, whoa, hang on. This leaves us totally exposed, because we've had that agreement covering our backs for 2 years. Now what's going to happen? So at that point, we had to enlist the lawyers to come in and have a look. And we also enlisted, finally, after lots of going backwards and forwards, we got a tech guy to come in and actually assess what the real value of this was. And ironically, after all this wrangling back and forth with the agency, it turned out that if any other person wanted to come along and set up something similar, that actually the technology's moved on so much in the 4 or 5 years, if they were going to build it, they'd do it in the latest version of the technology. They wouldn't be interested in buying this from the agency. Much as it's still totally useful for us, it's not useful for anybody else. So the value, you know, it's worthless. So it didn't actually matter that we didn't pay for the IP. However, what was the problem is that as a young business and as 2 entrepreneurs with God knows how many different hats that you have to wear within an organisation, got totally sucked into this issue. It took so much time and energy. We had to get the lawyers involved. And also, we were dealing with an agency who was still doing our web development. So it's a really sensitive situation to find yourself in. And it would have been so simple how we just have put in the contract, we're going to be developing this and we will own it. That's all it needed, those one words. And I think that my words of advice here were, we got a friend who was a lawyer to look over the contract, and you'll do this as young businesses. You can't afford the big legal fees. We paid her in shoes. You know, you trade anything when you're starting out. But she wasn't kind of from a tech background, so she hadn't thought of this, and we hadn't thought of this. We just thought we automatically own the IP. So we were damn sure when we developed our iPad last year that we did own the IP for that. But yeah, it's really worth kind of thinking these things forward.
I might skip over to the next slide given the time, because I think we sort of pick up a few of the points on this slide. Particularly, I think an important one when you come to running your business is looking at handling personal data. You know, and so the previous slide had there sort of preparing a privacy policy, which is actually a requirement in many jurisdictions, Hong Kong, the UK, a number of others, that you have to have a notice on your website about how you're going to use personal data. But I think and so that's an important thing to put in place when you're getting your website up and running. But I think the really important thing to remember is that just by having a privacy notice on your website, once you are up and running, doesn't magically dispel all of your obligations with respect to personal data. Even looking at the Hong Kong situation, we've got the Personal Data Privacy Ordinance. That has this requirement for giving notice on how you'll use personal data, but there are also a suite of other obligations about how you use personal data, how you handle personal data, how you secure personal data, how you use personal data for direct marketing purposes. And I'm sure all of you have been bombarded with notices in the last few weeks as the law has been changing with respect to direct marketing, where people are trying to shore up their position with respect to direct marketing and that wanting to be able to continue to use your data for that purpose. So, it's really important to look at, particularly if you've got a business that's going to be collecting, customer data and using it, that you are actually handling it and securing it appropriately and, putting in security so that it's protected from hackers. Not selling lists to business partners, that's a really key one. That's how Octopus got into trouble a few years back. They sold their customer lists for a very nice sum, but suffered a massive reputational damage as a result, so it ultimately didn't pay off. And the other thing is being very careful about buying lists to do like blasts of emails, for example, because that can also seem quite an attractive way to get more, to get more attention to your business, to your site. I'll just buy a list, do an email blast, or why don't I just take the Law Society list of lawyers and my services will be appealing to them. I'm just going to send them all emails. The regime now is that if you buy lists or use lists, before you can actually do your email blasting, you need to get consent. You need sort of an opt-in type consent from individuals before you use their personal data for direct marketing. So, it's very important to have your privacy notices in place, to get appropriate consents, so that you can use your customer database that you've built up appropriately and to understand that. And there's a load of information on the Privacy Commissioner's website, so you don't necessarily need to go to lawyers to get that information. You can self-educate quite a lot on there. There's information for consumers, there's information for businesses, there's more legalistic stuff, so there really is a lot there, but it's very important to understand that from a data protection perspective, as well as to being able to use that data for marketing and to grow your business.
I think when you're trying to grow your business, there's nothing better than actually having an audience that's opted in and is engaged with your email marketing anyway. You'll get much better value for your money rather than trying to hit a load of people from a list you've bought in, because I just think it's really detrimental to your brand. I don't see the benefit personally.
The other thing that I just wanted to highlight there was consumer protection laws and handling returns and complaints. Now, we're quite lucky in Hong Kong in one respect, well, as business operators, not necessarily as consumers, in that there's very little in the way of consumer protection law. So when you are sort of, building a business, you don't have to worry about, particularly an online business, about having returns policies that comply with particular statutory periods or giving a cooling off period. A lot of the things that you particularly see in Europe, you pretty much can sell something, and unless there's something desperately wrong with it, you don't have to take it back. So Hong Kong is quite an open environment, but that's Hong Kong. So if you are dealing outside of Hong Kong with other jurisdictions, just because you're selling from Hong Kong doesn't mean you can take that approach. You need to, if you've got consumers in other places, you need to understand the laws about returns, cooling off, etc. in those other places, so that you're not pulled up by a consumer body in another country. So that's the key thing there. Is there are, just because we're operating in this lax environment, don't ignore the strict regimes elsewhere.
Yeah, I think the UK certainly is much tighter on that whole kind of returns policy thing. And I think we were exempt from some of that because we've got a custom product, but we decided to actually give our customers a full returns, open returns policy, because we were, as a business, we were kind of conscious that as a new concept, it's kind of, what if it doesn't fit, or what if I don't like it? So we decided to put that policy in place. But around it, we built some some guidance into our T's and C's to say, look, if you're going to return it, then you need to let us know within 7 days, and you need to then return the product to us within 2 days. Because if you don't kind of close those things down in your T's and C's, you leave yourself pretty exposed. And you could potentially have customers returning product 12 months down the line, and you've got to find the refund, for them. So, you just want to make sure that these things are kind of fine-tuned.
And so then the last point on this slide really was just about, web hosting and ongoing maintenance of your site, because in many cases most cases you'll have a third-party provider hosting your site. And the key thing here is really, if you're using a host, to understand what the service is that they're providing, what the level of services that they're providing in terms of uptime and what they'll be doing for you in terms of servicing your site. And then when you are entering into a contract with them, making sure that the glossy brochure matches what actually ends up going in the paper, in the contract, because there's very often a mismatch. And very often those contracts that you get, particularly from the larger service providers, will be very one-sided in their favour and very difficult for you to challenge. So worthwhile having a look at, are they actually signing up to what they've said they're going to do? And if they don't do it, is there any real incentive for them to do it? Can I not pay them? Are their fees reduced? What are the outcomes? And as a small business, it's probably going to be very hard for you to negotiate those terms. But if someone has got particularly onerous or difficult terms, it might be worth shopping around for another web host who will suit your business better, or maybe a little bit more flexible or sympathetic to a small operator.
I think also some of the big companies, realistically, they do tend to try and squeeze things into their terms that they hope as a small company you're not going to notice. We just had a very similar example with a big company who's a kind of group buying company in the UK, and we totally missed in the contract the fact that the VAT obligation was going to be on us instead of them. Anyway, cut a long story short, the commercial dynamics of the deal we did were totally different because of this small clause in the small print. And I think, the lesson we've learned from that is just to shut yourself away in a dark room, go through the contract with a fine-tooth comb. If you're anything like me, you hate this kind of level of attention to detail. It's horrific, but do it because it's so important for your business. It's so important. If you've got questions and queries, do go back and challenge the third party, because it may be that they're trying to squeeze these terms in and they know it's borderline. And actually, if you challenge them on the point, they concede, because obviously there's a reputation risk for them. So don't be afraid to challenge the other party. And then obviously, if you're still not comfortable and you have some concerns, then at that point really would suggest either finding somebody else or talking to a lawyer.
So I think on that we're going to wrap up. If we've got any other questions, we do. Do you want us to wrap up and take questions afterwards, or are you okay?
I think we can take these three and then we'll...
Okay. All right, great.
Hi, I have two very quick questions. So the first one's relating to personal data. So if somebody buys, let's say, your product online, shoes, and has her email address, right, are you then legally allowed to send her marketing? What if she checks like the opt-in to like marketing emails box? Then it's okay. Like, how does that work? So that's the first question. The second one is location-based. I'll get back to you after that, right after this.
The first question is, well, it's different in every country. In Hong Kong at the moment, essentially, if you do have an opt-in and you are very clear about what someone's going to receive if they opt in, then that's fine.
I think if they've bought something from you and they've given, correct me if I'm wrong, it might not be the same in Hong Kong, but if they've bought something from you and they've given you their email address, you can communicate with them about their order. Right. But you're not allowed to give them any marketing messages, and it's so tempting sometimes to want to do that.
Illegal.
You can't. No marketing messages. It's just about their order, any information related to that transaction.
Got it. Thanks. Yeah. So second question actually goes back to where to set up your office. So I'm based in Hong Kong, but my target market's actually, let's say, in the US. But obviously for tax reasons, I'd rather just have a company here. Is it illegal actually to not have an entity there if I'm selling just online there? I have no retail presence, or?
It's different in every country, but it's not necessarily illegal. I mean, if you're running your business from Hong Kong, and unless you're kind of evading tax or doing something untoward, then there shouldn't be any reason why you can't deliver to another country. But it doesn't exclude you from the laws of that country. So like we're saying, you still need to pay attention to US consumer protection laws, even though you're not physically there. So,
like, what is the criteria for having to set up an office in a country? Is it a sales presence, like a retail store, or an office in that country? Is there?
Again, it varies from country to country. It will often depend on a number of factors, not any one factor. So how big your operations are, whether you're actually entering into business contracts in that country, really whether you've got employees in that country. that's often a key one. You know, if you're saying, oh no, they're actually employed by my company back in Hong Kong, but they live in LA, well, that kind of, you know, that you'll get more nexus to that country. And often it may not even be that there's a requirement to set up a company there. It's just that the tax man in that country will find you. So.
I just have two follow-up questions. So the first one is, does the right to use include the right to amend? So say
You mean talking about copyright?
Yes.
Not necessarily. So it will depend what your contract says, because your copyright's owned. If you haven't got an ownership of the copyright and assignment that we were talking about, then you're at the mercy to some extent of what the owner says. And if your contract only says you can use this for your business, then that's what you're limited to. But it may not mean that you can go in and change the code. It may, but it may not. Will depend on what the contract says.
Okay. My second question is, if my brand name, like Upper Street London, has a location, and if I were to register a trademark in China, is there any suggestion to protect my trademark? Because I can't really use the location name, which is a part of our brand name.
Yeah. The location thing is that the reason why they want you to take that out is because they don't want you to end up with monopoly over the word London. That's the reason. So they don't want, if someone else then comes along and wants to register a shoe brand called Women's Shoes London, then they don't want Upper Street London to be able to say, hey, I've got exclusivity in the word London for shoes. So that's kind of the reason that that location delineator is out. But I mean, if you could argue that was a really distinctive part of your brand and it was essential to your brand name, then you may be able to get it past. It's not an absolute not an absolute prohibition on places, but it's more difficult to register marks with place names.